In the case of Masonic Temple Association versus Michigan Fire and Marine Insurance Company, the judge expressed his opinion that if there was an appraisal, the parties might adjust their differences and end the litigation. Similarly, Judge Masaki stated that a court generally reviews disputed questions of law after an appraisal is complete, but this timing is not mandatory.
The interplay between the appraisal clause and arbitration. The appraisal process and the arbitration process both act as forms of alternative dispute resolution. Both are very mechanically similar, and thus courts often conflate the two terms. Furthermore, numerous courts around the country have taken guidance from cases and statutes relating to arbitration, causing a state-by-state split. This has caused a majority view and minority view. The majority opinion holds that insurance appraisal is actually distinct from an arbitration. A number of basic distinctions have long prevailed between an appraisement under the standard fire policy and an arbitration. An agreement for arbitration ordinarily encompasses the disposition of the entire controversy between the parties upon which judgment may be entered after judicial confirmation of the arbitration award. In contrast, an agreement for appraisal extends merely to the resolution of the specific issues of value and the amount of loss, with all other issues being specific issues of value and the amount of loss, with all other issues being reserved for a determination in a plenary action. An appraisal is an informal, independent investigation conducted by individuals who base their decisions on their own knowledge. An appraisal is generally conducted without hearing or judicial inquiry. In contrast, arbitration is a quasi-judicial proceeding, complete with formal hearings, notice to parties, and testimony of witnesses. Based on these substantive and procedural differences, numerous jurisdictions have determined that appraisal clauses included in insurance contracts are distinct from agreements to arbitrate. To date, this continues to be the majority rule in American jurisprudence. However, an emerging trend in several jurisdictions has shifted this long-standing traditional view. For instance, courts have explicitly held that appraisal is a species of arbitration.
Depending on your insurance policy, many insurance policies will give the option to go through the appraisal process. The appraisal process is when both parties get to select their appraiser, appoint an umpire, and that determines a specific, unique set of circumstances pursuant to your policy, typically a valuation of your property damage. This is different from an arbitration, although it's very similar, and Florida law has particular legal distinctions between the two pursuant to case law. But the easy answer is arbitration is presided by an arbitrator that can decide a wider scope of issues than what an appraisal is actually meant.
In the case of Masonic Temple Association versus Michigan Fire and Marine Insurance Company, the judge expressed his opinion that if there was an appraisal, the parties might adjust their differences and end the litigation. Similarly, Judge Masaki stated that a court generally reviews disputed questions of law after an appraisal is complete, but this timing is not mandatory.
Insurance Appraisal Mini-Course. Valuation Methodologies. In some cases of disagreements as to which valuation method to utilize or even what a particular valuation method accounts for, definition or guidance by the court is actually required in order for the panel to determine the amount to be awarded. Because the appraisal panel cannot interpret the meaning of the insurance contract or define valuation terms in an award, the only way to resolve that is for the panel to consult the direction of the court of record. However, by being proactive, the parties can draw up an appraisal memorandum to define all potential valuation methodologies, as well as to specify which ones are called for in the instant appraisal. Without something like this, much can go wrong and much will not be resolved. Perhaps the best example of the need to clearly define terms for the appraisal panel is found in Elberon Bathing Company Incorporated versus Ambassador Insurance Company. Here, there was a disagreement on the amount of loss, and the parties elected to settle the valuation dispute by appraisal. The insured's appraiser and court-appointed umpire awarded replacement cost as the actual cash value loss. The insurer's appraiser refused to sign the award. The award was ultimately overturned because New Jersey law requires consideration of a broad spectrum of evidence, known as the broad evidence rule, to determine ACV, and the panel's award was based on a method that did not apply the New Jersey broad evidence rule. This clearly illustrates the problem that even in those cases where clear instructions are given, appropriate definitions or court rulings are required for the panel to properly appraise the loss. Please read the Elberon Bathing case, which is included in our e-course system, and answer any of the questions toward the end.